Good morning, everyone, and welcome to this week's webinar. I am glad and delighted that we have finally come to this position where we can talk about post-election disputes. My name is Julie Wayo-Madheka. I am a program manager at the Kenya section of the International Commission of Jurists, ICJ Kenya. And this webinar is jointly convened by ICJ Kenya, the Law Society of Kenya, and our partners, the judiciary. We will be hearing from each and every one of these entities as to the preparation that they have done to handle post-election, particularly election disputes. So right now, everyone, welcome to this week's webinar. I am glad and delighted that we have finally come to this one. So right now, we are going to hear from our valued partners, and this session will be moderated by my colleague, Madam Faith Odhiambo, who is the Vice President of the Law Society of Kenya. Keep this conversation interactive by talking on the chat section, the question and answer session. We can also post on our various social media platforms, ICJ Kenya on Twitter, Law Society of Kenya 1 at Twitter, and the judiciary on Twitter. So we can also have this conversation going online. So I'd like to invite Madam Faith Odhiambo to introduce our various guests who will give our opening remarks. Over to you, Faith.
Good morning, everyone, and thank you, Julie, for the introduction. So today we are joined by our various partners who will be presenting on the issue of the election petitions, and particularly the judiciary will be talking on the filing system that they have set in place to ensure ease for lawyers who will be filing their matters during this period. So first of all, I would like to introduce the chair of the ICJ Kenya, Protas Saende, to give his welcoming remarks and also remarks towards the preparations that the ICJ Kenya have done as we come to the close of the elections and we start with the court processes. Welcome, Protas Saende.
Thank you, Faith. President, Court of Appeal and Vice Chair, Judiciary Committee on Elections, Honorable Justice Musinga, President, Law Society of Kenya, Mr. Eric Theuri, Vice President, Law Society of Kenya, Faith Odhiambo, Deputy Registrar, Judiciary and guest speaker for today, Honorable Elizabeth Tanui, Advocate of the High Court and invited speaker, Mr. Ochiel Dudley. Ladies and gentlemen joining us from various places on this webinar, good morning. Now, the Republic of Kenya is founded on ideals of democracy, sovereignty of the people, and the rule of law. Democratic elections provide the most legitimate mechanism for constituting the social contract between the citizens of Kenya and their government. Therefore, the conduct of free, fair, and transparent elections is an essential prerequisite for the existence of the democratic system of government envisioned by our Constitution. Colleagues, election-related disputes are an intrinsic part of electoral process, and the credibility of that process is determined to a large extent by the capacity of the state to resolve these disputes effectively. In the 2017 general elections, 388 election petitions were filed in the High Court and Magistrate Courts, whereas in 2013, 188 petitions were filed. The upsurge in the number of petitions filed is evidence of our judicial system's strength, vitality, and openness, which is partly attributable to an increase in public understanding of the process of seeking redress through judiciary. So in the just concluded elections, candidates used their predetermined pre-election dispute resolution mechanisms, such as the internal party dispute resolution mechanism, the IEBC dispute resolution committee, the political parties dispute tribunal, and sometimes the High Court and Court of Appeal to resolve the disputes that arose before the elections. Kenyans have therefore demonstrated faith in the justice system as the impartial arbiter of any disputes. Today, we are expecting that the presidential and deputy presidential candidates of the Azimio la Umoja One Kenya coalition will be filing a petition challenging the election outcome. This shows the importance of a strong electoral dispute resolution mechanism. Colleagues, the judiciary has a vital role in promoting free and fair elections in the country. As the ultimate custodians of our country's constitution, the court must always uphold the rights of the voters. On the other hand, the litigants play a critical role in ensuring access to justice for the petitioners in an electoral dispute resolution. In the past two election cycles under the Constitution of Kenya, the Judiciary Committee on Election had a duty to coordinate and collect all matters filed in Kenya challenging the election outcome. The coordination aspect was challenging because of the lack of a centralized system, which led to the Secretariat calling all the stations to ensure the judicial officers and judges were well equipped to handle the matters before them. In 2013 and in 2017, ICJ Kenya supported the committee by undertaking a novel task of developing compendiums on all election-related disputes. The compendiums can be found on our website and available for downloading. ICJ Kenya has worked with the committee from its inception. Today, ICJ Kenya commends the judiciary for achieving a significant milestone in rolling out the e-filing system and its guidelines. This system will ensure parties and advocates can file their matters digitally and ensure smooth coordination across the country. It is against this background that ICJ Kenya, in partnership with the judiciary, through the Judiciary Committee on Elections and ICMS Committee and the Law Society of Kenya, finds it timely to convene litigants, scholars, and jurists to discuss in depth the requirements of filing an electoral dispute in a court of law. Therefore, I hope this webinar will be resourceful in your quest for rich and well-informed expert opinion, current practice, and emerging jurisprudence. With those few remarks, thank you. God bless you all, and God bless Kenya.
Thank you, Chair of the ICJ Kenya. Now I'd like to welcome the President of the Law Society of Kenya, Mr. Eric Theuri, to give his welcome remarks and also comments on what the Law Society has done with regards to preparation towards the electoral period. Thank you.
Thank you, Vice President of the Law Society of Kenya, the President of the Court of Appeal, who is also the Vice Chair of the Judiciary Committee on Elections, the Honorable my Lord Daniel Musinga, the Vice President of the Law Society, the Chair of the ICJ, the Deputy Registrars present, and all staff of the ICJ present. Good morning, everyone, and of course, all the advocates who are also joining us on this call. We are delighted to be able to host all of you on this call today. Of course, noting the significance of the day. This is the last day in which the presidential petition ought to be lodged, and we are sort of in a way pregnant with expectation that the petition is going to be filed today. And of course, we are prepared for the long night of reading to be able to appreciate what the petition will be saying, be it one or be it two of those petitions that are going to be filed. It is, of course, then of greater significance that we are having this discussion. It is part of an ongoing discussion that has been undertaken by the Law Society with also the various stakeholders, including the judiciary. And just the other day, the e-filing platform for the EDR was launched by the Honorable Chief Justice. And of course, we expect that advocates have begun to interact and familiarizing themselves with the filing system, which of course we believe would be able to ensure that we have greater efficiency in terms of how we manage the court, the petitions that are going to be filed in court. Of course, we were quite delighted to note the fact that the proceedings and the record of the proceedings are likely to be available within a very, very short time, which of course for us is a further improvement on the system, and we commend the judiciary team that has worked on that. As the Law Society, you're also probably aware that we will be having a webinar this Friday, where we would also be examining the question of prosecution of election petitions, including how to structure the election petitions, how to avail a source for the evidence to support the election petitions and all the other issues. This is part of an ongoing discussion that has been going on between during the various CPD trainings, and we hope that with those trainings and with everything that we have been doing, we have had an opportunity to prepare the advocates as well as the judiciary has been preparing its membership. We also, of course, are alive to the other challenge that we may expect. If we look at the trajectory or the statistics in 2013, I think we had about 188 cases. In 2017, we had about 388 cases. So if you look at that trajectory, there's a possibility that the petitions that we may face, the election petitions that we may face in the High Court and the Magistrates Court are likely to increase. And that, of course, will cause a significant strain on the capacity, especially of the High Court, to handle those cases. But we are sure, we know that this is still an ongoing conversation, and we know that quite a number of us are a bit concerned about how the judiciary is going to handle that, but we are going to stay in close consultation with the JCE and the leadership of the judiciary to ensure that if the number of cases that are filed is high, then that those do not affect it significantly the manner in which we also run and handle the other cases that are not concerned with the elections. So I would want to just take this opportunity to welcome all of us, those who are in this call. We hope that the discussions that are going to arise in this webinar are going to be thought-provoking, that are those that are going to inform and improve your ability to be able to handle any disputes that you may come across, or also just improve your understanding of the EDR process, the laws, and the certain thresholds that are required to successfully prosecute or defend an election petition. So I welcome you to this discussion, and I look forward to learning from the other presenters that are going to speak after me. Thank you so much, and Madam Vice President, it's now over back to you.
Thank you so much, Mr. Eric Theory, President of the Law Society of Kenya. Last but definitely not least, I would like to welcome President of the Court of Appeal and the Vice Chair of the Judicial Committee on Elections, Honorable Justice Daniel Musinga, to give us his remarks and also the steps that the JSC has taken to ensure that they prepare for the petitions that will be filed before these courts. Thank you.
Right. The President of the Law Society of Kenya, Mr. Eric Theuri, the Deputy President, the Chairman of ICJ, Mr. Prota Saende, Mr. Dudley Ochio, a distinguished legal practitioner and presenter in today's webinar, and other members of the Law Society of Kenya present, members of the JCE present, including Elizabeth Tanui, a presenter in today's webinar. Ladies and gentlemen, good morning once again. I believe this is the first public function JCE is holding after the recently concluded general election on the 9th of August 2022, and now is the season for filing and hearing of electoral disputes that arose therefrom. Electoral stakeholders are increasingly turning to dispute resolution mechanisms to resolve contests for political power. This is a positive trend as contestants use legal means to redress grievances rather than resort to violence. The effective resolution of electoral complaints is integral to the integrity and legitimacy of an election. The rules and procedures developed by the courts before the promulgation of the Constitution of Kenya 2010 led to the perception that courts could not give timely and effective remedies to bona fide petitioners, and this undermined public confidence in the judiciary as an honest arbiter of political disputes. And due to this perception that courts could not honestly arbitrate political disputes, the aggrieved side refused to refer their dispute in 2007 presidential election to the court, and leading to unprecedented loss of life and property in the violence that ensued following the declaration of the disputed results. On good governance, the Kenya Constitution 2010 provides when and how to conduct elections. Elections, as we know, provide citizens with an opportunity every 5 years to determine the people they want to lead them. In the event of electoral disputes, the Constitution authorizes the judiciary to resolve them and sets out the timelines within which they should be determined, as well as the rules and procedures to be followed in such exercises. The Constitution of Kenya 2010 and the Elections Act 2011 have established a fairer, more efficient, modern, and legal framework for the conduct of elections and the resolution of electoral disputes. To deliver on its mandate, the judiciary has a standing committee, that is the Judiciary Committee on Elections, in short, the JCE, which spearheads administrative arrangements and capacity building measures for judges and judicial officers, and generally prepares the judiciary to efficiently and expeditiously determine electoral disputes that arise from general elections in our country. The effort of the committee enabled the judiciary to determine, within the set timelines, the 188 and 388 election petitions that arose from the 2013 and 2017 general election, respectively. Under the aegis of the committee, the judiciary has put in place preparatory arrangements for the resolution of electoral disputes that have arisen from the recently concluded general election. the committee has carried out a wide range of activities in preparation for the anticipated election petitions, the key ones being the following. 1, intensive refresher training for the judges and magistrates who will handle electoral disputes. 2, the committee has been at the forefront of reforming the election disputes resolution EDR laws and has consistently engaged the National Assembly on this. 3, the bench book on electoral disputes resolution has been revised and updated. This is a quick reference guide to be used by judges and magistrates as they handle election petitions. The bench book contains summary procedures in EDR. It highlights key legal provisions from the Constitution, the legislation and regulations governing EDR, and the relevant jurisprudence in thematic areas. It also provides a quick reference of key resources and authorities. In partnership with the Directorate of ICT, the Integrated Case Management System, ICMS, has been customized to facilitate online filing of election disputes. The filing process of election disputes in the previous election cycles was purely manual. The same was costly, time-involving, and inefficient. With the e-filing system, litigants are enabled to file, pay, and register their cases in all courts across the country from the comfort of their offices or residences. This system will also allow JCE to monitor in real time the progress of petitions across the country. The system has been tried and tested. The 188 disputes from the party primaries were filed and processed successfully through the platform. So far, 4 petitions relating to MCA positions from the 9th August 2022 general election have been filed through the platform. And I believe the presidential election petition has just been launched a short while ago. It has been filed electronically. I invite you, ladies and gentlemen, to take this opportunity to learn and understand how the system works and make proposals on how the same can be improved to ensure that we have a simple, transparent, and accessible mode of filing. On behalf of the chair and membership of JCE, I want to assure the legal fraternity and the country in general that the judiciary is ready and well able to resolve all electoral disputes that have already arisen from the general election and those that may arise, those that may come after the IEBC concludes elections in the remaining areas. In conclusion, ladies and gentlemen, I want to take this opportunity to thank all the development partners and stakeholders, including IFACE, LGR, and in particular ICJ, Katiba Institute, UNODC, LSK, among others, who have so far worked with JCE in undertaking all the programs that we have carried out so far. To all of you, I say thank you and God bless. Welcome to this important webinar today.
Thank you so much, the Vice Chair of the JCE, for affirming the position that the judiciary is well able and capable to undertake any judicial disputes that may arise, and that you have set in place a simple, transparent, and accessible system for online filing. And we are looking forward to interacting with the system. And thank you so much for affirming also the position of the judiciary and to the public that you're capable and you're up to the task. So I think I'll hand it now over to my colleague to take us, Nelly, to take us through the next session. Thank you.
Thank you very much, Madam Vice President, for taking us through that session. And thank you to all our guests for their remarks. Now we are going into the substance of the conversation. And we'd want to start with Dudley Ochiel, advocate to the High Court, litigator, who will take us through what is the form and structure of an election petition. What are those issues we have to have as advocates at our fingertips as we go into the courts? What documents do we need to have? And what forums should we address our matters to, depending on the various positions that are being contested and have been challenged? So I want to welcome Dudley, give us an overview, sharing his experiences and also what are the tips and tricks that advocates need to have at their fingertips as they go into this next busy session. Over to you, Dudley.
Thank you, Julie. You know, after my chairperson put aside had indicated the rule of law reasons why it's important to consider the election petition jurisdiction, I thought that my other chairperson, Mr. Eric Theuri, would speak about the economical reasons. Some of the reasons my friend Steve Ogola had alluded to. We need petitions filed because it makes us money. Anyway, just a note of caution. It appears that the election petition jurisdiction is so special that it has its own complete set of rules. I have filed many matters before the Supreme Court. I've never been required to file one by 2 p.m. But the presidential election petition rules require you to file it by 2 p.m. That's a separate rule. It's a special rule that only exists for the presidential election petition. The issues of security for cost, for example, is another example. And also, if you come to the Court of Appeal election petition rules, in all other cases, you file your notice of appeal at the court where you're appealing from, at the High Court. The Court of Appeal election petition rules require you to file your notice of appeal at the Court of Appeal. That's a special rule that also only exists for election petitions. So in short, a disclaimer, you'll have to go down to the specific rules, the Supreme Court presidential election petition rules, and look at it entirely. The Court of Appeal election petition rules and look at it entirely. And the other one applicable to the High Court, the parliamentary and county election petition rules 2017, which applies to the Magistrates Court and the High Court, and look at it entirely. The rules tell us, if you look at Rule 5, for example, of the parliamentary and county election petition rules, that the consequence of your non-compliance with the rules would be determined by the court considering Article 159. That is important because, for example, if you remember Martha's case, one of the reasons why it was thrown out, Martha Karua, was that she had failed to state the date of declaration of the results and the rules required. That cost her time, it went up, the decision was reversed, but when she came back down, 6 months had elapsed and the matter ended up at the ESCJ. So you need to look at the rules and see what do they require. They seem to be quite particular on certain issues, and I'll just highlight some of the requirements of the rules so that we have sufficient time for the Honorable Dia Tanui to tell us what are the practical aspects. You know, she's the one who will be receiving your petitions, so we better listen to her on what she's going to tell us we need to do with them. And things like whether we still have to serve in the newspaper, considering e-filing and the advances we've made in technology since the 2017 round of disputes. So in terms of forum, if you're challenging the election of a member of county assembly, you file it at the resident magistrate designated by the Chief Justice. The others, member of National Assembly, governor, woman, county representative, and senator, go to the High Court. So if you file at the resident magistrate, it would mean that you'll have 2 levels of appeal. You appeal to the High Court. in accordance with the rules, and then you appeal to the Court of Appeal, and it would end there. If you file at the High Court, you'd also appeal to the Court of Appeal, and depending on what is raised in the petition, you may be allowed to appeal one last time to the Supreme Court. It's taken a number of those petitions, depending on the subject matter and how it's framed. On the content and form, you need to obviously mention who's petitioning, and that can be a candidate or a voter or any other person. An institution I've seen has filed a presidential election petition before in 2013 because of the expanded standing that we have under the current constitution. Then you also need to indicate when the election was conducted. Obviously, that's 9th August, although it would vary for by-elections or the elections that the IBC has stood over. Then you have to indicate the result of the election, if any, and in whatever manner they were declared. There's sometimes when the result is declared orally, but then it's different from the form. The oral result is declared, but it's different from the form. So you need to state that the oral results declared were these, but when we look at the form, what we find is different. So you have to state what the result of that election is, and the date when the declaration of the election was made. That's important because jurisdiction depends on the date. If you are challenging elections other than the presidential election, you have 28 days from the date of the declaration of the result. If you're challenging the presidential election, then you have 7 days. So the date of the declaration is a jurisdictional point. It's important to help you to calculate the period within which you should file. And then you state your grounds on which the petition is presented, including the validity of the declaration made and the question whether an alternative candidate had won and should be declared, and then the name and address of the petitioner, which will be used for service. Then when you come to your reliefs, you'll be looking at things like the declaration, whether the candidate declared is the one who won, or whether there's someone else who should be declared. That's a debate I've seen our colleagues on Facebook argue the question animatedly. Whether the court can declare maybe a president-elect, the court can make a declaration of a president-elect. I think they're speaking about the current petition, anticipating what has been sought or not sought in it. Then you have to indicate whether you want a fresh election. In the presidential contest, it could be a runoff or a rerun, and whether you're seeking scrutiny and recount of the ballots. And that's important, where you are alleging that if you count the results, the ballots again, then you will arrive at the conclusion that a candidate other than the one who was declared is the one who was validly elected, or that scrutiny will reveal that there were irregularities which affected the outcome of the election. Then the issues of payment of costs, and that will be linked to the question of security for costs. For the presidential election petition, you have to deposit 1 million shillings. Maybe that's why we don't see a lot of those petitions get filed. For the county elections, other than MCA, it's about 500,000 shillings. And for the MCA, the security for costs is 100,000 shillings. And then you have to indicate whether you'll be asking the court to determine whether an electoral malpractice of a criminal nature may have occurred. You'll remember the Wetangula case from 2013, where there was a determination that there was voter bribery, and the matter went all the way to the Supreme Court, which directed amendments to Section 87 of the Elections Act. So Section 87 in its current rendition requires the court, says that the court may determine if a malpractice of a criminal nature may have occurred. And if the court determines that an electoral offense may have occurred, the court reports that to the DPP, who has 2 years under the Electoral Offences Act to prosecute such offences. I think I will stop there for now and go back to where you are.
Thank you very much, Dudley. As you were presenting, I was thinking to myself, 1,500,000, 100,000. And if you don't know the technicalities around these costs, you might find yourself in a difficult position after your client asks you why the petition was not successfully filed. I think the other question is, what are the kind of interlocutory applications that you have to file at the elections court? And at what point should you file them?
Well, if depending on what you've pleaded in the petition, if you're seeking scrutiny, you'll have to do the scrutiny before the petition. So you file an interlocutory motion for scrutiny, and you have to be specific. You set out which polling stations you're doubting. For the presidency, I think it would be which constituencies or counties you're doubting. So you need to know or suspect what you think is in the ballot, because you could apply for scrutiny and then it surprises you. It returns the opposite result. You file it before case management so that it's dealt with before the main hearing of the petition. That's when you file your motion for scrutiny. I think for the presidential election petition, we've seen motions for scrutiny of the IBC portal, the KIMS kit, electronic system used to manage the presidential election petition. There's something that's curious which happened in 2017. Once the petitioner made a successful request for scrutiny at the national level, then many of us advocates copied that and went with it down to the other elections and tried to achieve the same result. But see, the result management system is different. And that's why I was saying that we must look at the rules. President will not suffice. You must just look at the rules and see what it requires you to do, depending on the election petition you file and on the reliefs you're seeking and on your grounds as well. Thank you.
Thank you very much. We will have an opportunity to ask Dudley more questions. So in the interim, you can put your questions down in the chat section. And once we get to the question and answer session, I can ask someone to either vocalize their question or we can answer them from the chat section directly. I know something that might be asked is, how long is the appeal process? And if you start at MCA level, can you go all the way to the Supreme Court? So I will leave that pending for now, and hopefully we can address it in the question and answer, because some people might have a very long litigious journey ahead of them. So for now, I want to invite Honorable Tanui, who has been spearheading the ship on digitization at the judiciary. She's an ally to ICJ Kenya and has walked us through the process of developing this very useful resource that advocates will be using, as well as academia, civil society, and people who are interested in generally the court process will be using this as a tool to find out how many matters have been filed, who has filed them, what is the process, where are they at. So I want to invite Honorable Tanui to just give us a background as to why they established that digital transformation is the way to go in matters elections. Over to you, Honorable Tanui.
Thank you so much. Really, it's a pleasure and an honor for us to be part of this conversation, especially after the Honorable Chief Justice has launched the e-filing online platform and the guidelines there too. So I come in as a team. I am serving currently at the Commercial and Tax Division, but also supporting the ICT activities in the judiciary. I am with Neville. Neville is a software developer. He will be taking us through the demo of the system. I'm also with Yvonne Bai. Yvonne Bai will take us through the frequently asked questions. So we are a whole team ready to unpack the e-filing platform to the law society. So I will contextualize why the e-filing platform, and I have a presentation which I would wish that it was put up. I will explain why the e-filing platform arising out of the experiences that we have had. So we are the whole team ready to arising out of the experiences that we had in 2013, 2017 on, I mean, sorry, manual filing. The vice chair, that is Daniel Musinga, has explained that in 2013 and 2017 election cycle, our filing process arising out of we have learned lessons from the filing processes. If you could just skip to slide 2, I will take us through the lessons manual have learned. The lessons that we learned from the election cycle has informed what we did in 2017, and I will just take us now through what our filing processes were. So let's take the next slide kindly. You can move to the back. So what you're seeing on the screen is basically a workflow. Slide 2, I will a petition which is filed. This was the court and the magistracy court and the presidential election. So we are looking at the filing of that petition this entire workflow in terms of after you have filed basically a workflow. Slide 15 petitions is thereafter, and then on the last day of the receipt of the last response, then we have the pre-trial. So we are looking at hearing a trial to be held on judicial system. All that so we have tried to customize the online filing platform as basically a workflow. Slide 15 petitions is thereafter, and then on the last day of the receipt of the last response, then we have the pre-trial. So we are looking at hearing a trial to be held on judicial system. All that so we have tried to customize the online filing platform as basically a workflow. Slide 15 thereafter, and on the last day of the receipt of the last response, then we have the pre-trial. So we are looking at customize the online filing platform as basically a workflow. Slide 15 thereafter, and on the last day of the receipt of the last response, then we have the am I good to go? Customize the online filing platform as basically a workflow. Slide 15 thereafter, and on the last day of the receipt of the last response, then we have the am I good to go? Okay, apologies for that. I hope I'm clear now. What you're seeing on the screen is basically a complementary and election petition life cycle that is virus. And I was explaining that we have customized the e-filing platform to mimic this particular life cycle. So that within 6 months, that case will arrive and analyzed and taking into consideration the filing not only of the petition but the responses and also for the filing of the court fees and the payment for the security of course. So this happened in 2013. 2013 election petition case management system. You will see from the slide that in 2013 we had an election petition management franchise that was developed to manage the election petitions. This is the 2013 election petition case management system. The particular 2013 case management system had very into working our registries. You can see from the screen there that let's have you come and view our registries basically. We have an election petition management franchise that was developed to manage the election petitions. This is the 2013 election petition case management system. management system had prepared a new voting registries. You can see the screen there that let's have you come and queue. Registries basically an election franchise. We've developed to manage the election petitions. 2013 election petition management.
Let's start all over again. I'm now in a better position to lead this conversation. I said that I come in as a team. I am with Neville and Yvonne. We will basically be taking you through the online filing platform for the EDR matters and the guidelines that have been formulated there too. And the reason why we have an online filing platform is because of the lessons that we have learned from the 2013 and 2017 election cycle, where I explained that we had a purely manual filing system, and this manual voting system, like as EDR items, and the guidelines was really very expensive in terms of we had to walk to our registries, especially when you look at what happened with the lessons that in election cycle for the party primaries, where we had only one tribunal and people had to come all the way to file their petitions in the registry and then have them assessed and go to the bank queue and then come back to the registries and then travel back to their respective counties. It was a very expensive way of filing. So learning from those lessons, 2013, 2017, we have now developed what we are going to take you through today. So let's go now to the 2013 election petition case management system, just to show you what happened and the lessons that we learned therefrom. So I will go to slide 3. If you can please again slide 3. As I said, you have seen that what you're seeing on the screen is basically a petition life cycle for parliamentary and county elections. This is aside from the presidential one. Let's go now to the largely all petitions will follow this particular life cycle. And we have developed the system to fit this particular life cycle where you have to file your petition within 20 days and the responses and the timelines that have been put in there, and of course the deposit of security for cost of the files county election. What we have done with this system, and you will see, is that it mimics exactly what the rules provide. The rules have not been amended so that we can, for instance, work on filing through WhatsApp and but we have developed the system to mimic what the rules provide. We always say that we have built the system brick by brick, just being informed by what the rules are saying. So in 2013, how did we manage this particular life cycle? In 2013, we had a system that we had developed that was used to manage election petitions. But this system was dependent on you coming to the registries and queuing for purposes of presentation of your petition, and then you had to depend on that particular registry assistant to note and tell you that this is 15,100, and then you have to go to the bank, receive the payment, and then thereafter you have then to bring your petition to the court for purposes of now being stamped. For purposes of when you look at that, you can see you have to depend on the bank and tell you that this is 15,100, and then you have to go to the bank, receive the payment. So that particular system that we had developed at that particular time needed you to have filed in the registry for us to then scan and upload that particular management system. It didn't work for us. It didn't work for us because, as you can see from the challenges with this 2013 election petition management system, it had a capacity issue. The capacity issues was that system we couldn't access the documents as they were jumbled up in the system. So there was an issue with capacity for us to then scan. There was also an issue with timestamp particular management system. It didn't work for us. It didn't work for us because, as you can see from the challenges with this 2013 election petition system,
we want to apologize because there's a sound issue. I just want to say being hacked. Yes, we have established there's a slight. They were doubled down. Our technical team is working on it. So give us 2 minutes. We will be right back once we are sure that the sound is working. So just give us 1 minute to sort out the technical issue. Thank you.
All along.
Yes, people are really complaining.
Oops.
People think his position is old. All right. Cue us, guys. We need to go on. I need someone to be outside just to check the sound. So is it Joseph or Kendi? Can you just go outside and listen in from the room whether the sound is making sense? And then please mute, the other people can hear you. But tech team, we can hear you. Apologies for that. I think when you say when it rains, it pours. So we want to sincerely apologize from ICJ Kenya for that technical mishap, and also for the orbiter that you were privileged to in a few minutes ago. Now we want to cut back to Honorable Tanui, who was giving her presentation. We hope to have resolved the sound issue, and we can continue with the discussion that we are having. Thank you very much.
Thank you again, Julie. Apologies for that mishap. We are going to get right to the presentation. I said I come with a team. I will contextualize why the e-filing platform for EDR matters. I will have Neville take us through the demo, and I will have Yvonne, who is with us, do the frequently asked questions on the EDR platform. So why the EDR platform? I said we have done this platform arising out of the lessons that we learned in the 2013-2017 election cycle. So the 2013-2017 election cycle has taught us a lot in terms of how to be efficient and accessible as an institution. So we will look at the life cycle of a parliamentary and county election petition, which is largely where most of the petitions will lie, of course, other than the presidential election. So when you look at the screen, you will see that you have the entire life cycle where a petition has to be filed within 28 days from the date of declaration. And then once you have filed, the e-filing platform, as we will see through the demo, will process for you how to make payments, will generate an invoice for you, both for the filing fees and for the security for costs. And then will also enable the responses to be made. And then thereafter, there will be the pre-trial conference 7 days after the receipt of the last response. And then, of course, the petition has to be heard and determined within 6 months. So the 6 months period has been configured in the system so that there is a way, the system will alert us that the 6 months have since expired if you go outside that period. So I want us to look at the 2013, and it's good for us to appreciate where we have come from so that we can then also appreciate where we are going. So in 2013, we indeed had an election petition management system. It was a prototype. But this election management system that had been deployed at that time was dependent on you walking to our registries with your petition. So that once you walked to the registry, of course, you will remember what used to happen, and especially for registries in Nairobi, where it is now a forgotten story, that you would come and queue for purposes of presenting that petition to a registry official who would then have to assess it for you. The small signature from that registry official would be the activation button for you. So once we have signed that this petition attracts filing fees for 15,100, then you will have to go again and queue in the bank. So I want you to see the process that, it took. Queuing in the registries, queuing in the bank, and then you have to come with a deposit slip back to the registry for us now to stamp it for you, and then to then let you know that this petition has been filed by giving you a case number. So you will see, of course, during this election cycle that will not happen. The system will do all that. The fact that you will have your petition uploaded in the system, it will generate an invoice, you will make the payments, and you will have a case number. And of course, you will have filed from the comfort of your office, and it will take less than 20 minutes, of course, depending on the size and your efficiency as you navigate through the system. So that is what happened. There was a problem with the election petition management system at that time, where after you have then done, the entire manual process, we had to scan your documents, upload them, and then now send them again to Nairobi for purposes of, tracking and monitoring the petitions as they came in. But there was a problem with that management system. One, it had a capacity issue. It had no timestamp. We couldn't track. And then the secretariat had to keep calling, as the remarks came from, Justice Musinga. We had to keep calling across the court stations to just confirm how many petitions have been filed and at what stage those are in. So it was a very inefficient process for us, and we learned our lessons thereafter. But in general, as has been said, 188 petitions were filed in the 2013 election cycle, just using that particular process. The same thing happened in 2017. It was a hybrid management system where parties, of course, had to present again their matters to the court registries for purposes of assessment, but we had automated them in such a way that we could track the activities of that case. So it was hybrid because we could track, but then it was still manual because you still had to come to the registries and follow that process that I have explained. Handling the petition, the secretariat had to keep making calls to the in charges of the various election courts across the country to establish the status of the election petitions. Data would then be captured in an Excel sheet, which would be updated from time to time. But in this particular election cycle, that is 2017, the slide is slow, but if you could run through the slide to the 2017 election cycle, we are now in 2017, we had 388 petitions filed during that cycle. Now, just learning from this process, we have now developed the e-filing platform, which you will see. In this e-filing platform, advocates will access the e-filing system and lodge the petition from the comfort of their offices or from their homes, so long as you have internet connection. The election petitions filed, you will not have, any incidences of human interactions. Hence, they will be, we will avoid issues of corruption. We will avoid issues of delays. The timelines will be taken care of by the system. You will see that the system will show when you filed, at what particular hour to the second that document has been filed. So there will be no, conversations around when was this petition filed. The system will show us. Incidences of judiciary scanners breaking down. You remember I said in 2013, 2017, we had to scan what you have brought for purposes of sending them to the headquarters for tracking. There were, of course, issues of scanner breakdowns. We will not have it this time, and there will be real updates. This morning when I logged in, even when we were having this conversation here, we could tell how many petitions have been filed. Justice Musinga talked about 4 and the presidential petition having been filed. We have seen that 4 petitions have now been filed as at this time in the Supreme Court. So you can tell real time how many petitions are being filed, not only at the Supreme Court, but across the country. We have now a petition filed in Bungoma, we have one in Kangundo, we have one in Amisi. Just from the comfort of my office, I can tell how petitions are being filed and in respect to each elective position. The Secretariat can easily track, and establish the status of the filed cases. And then even you, in the comfort of your office, you can tell when a response, for instance, has been filed, when any other subsequent document has been filed. So for us, this particular online platform has cured many challenges that we had in 2013 and 2017. And as the Justice Musinga did say, we have tested this platform. Out of the 189 disputes that were, arose from the party primaries, they were filed and successfully processed through this system. Now, just an overview before we go through the entire demo now. The e-filing platform has been running for mainstream cases, but within Nairobi courts only. We are yet to have it cascaded down to other counties. We are in the process of so doing, but for EDR cases, we are ready to have this platform work for all court stations across the country. So for the mainstream cases, we can see that actively we have very active accounts. We have 12,333 accounts which are active as we are speaking now, which of course are made up of individual accounts, law firms, organizations, and state agencies. That is just an overview. And the features that I will want you to see when we are having the demo is that you will see the e-case registration feature. Remember that you had to come to the registry for purposes of being given a case. But the e-filing system now will generate a case number for you, so that the only way you will know that you have successfully filed is because you will have a case number. Of course, these are for the new cases. For the ongoing cases, there will be an acknowledgement from the judiciary. So one of the features that the system will show that has is the e-case registration, which is used to initiate remote registration of cases. Automated fee assessment. Remember, you had to come to the registry for purposes of fee assessment. Right now, that has been automated, and the system now will generate for you an invoice for each elective position. If it is the magistracy that is in respect to the member of county assembly, you will see an invoice for 15,000, for the High Court 30,000, of course for the Supreme Court 500. And it also comes together with an invoice in respect to the security for costs. So from the comfort of your office, you can have all this generated for you. And of course, we have the e-document management. This is in respect to ongoing cases, and e-service used to effect electronic service to case parties. This will be a conversation in terms of, will the e-service work for EDR? Remember what I said, this system mimics the rules as they are now, so that if the rules obligate you to serve directly or through the newspaper advertisement, you still have to do that. So we are not using this particular platform to amend the rules as of now. So it only mimics what we have in the rules. The e-filing system prerequisites, the prerequisites is that you have to have an e-filing account with us. You have to sign up to this. You also have to have your documents in soft copy and in PDF format and properly named, so that if you are filing a petition, please ensure that the petition is named as a petition, an affidavit, a plaint, and all that. And the maximum size of this is 50 MB. We will see what happens when we are doing the demo if you have a document which is above 50 MB. And of course, ensure that you have sufficient money, to use the online payment platform and internet. Then the EDR e-filing system. This you will see, this is just an overview. When we are doing the the demo, you will see that on the EDR system, EDR cases are categorized into 4 main categories. You will have, of course, the main one being the election petition, matters filed to challenge the results declared for a certain elective position in an election held. You will have the election appeals filed to challenge the judgment given on certain election-related cases, the party list, and the miscellaneous application. So keep a tab on this, even as you see during the demo, how you will navigate through to then file a party list petition or a miscellaneous application related to an election matter. This would be your dashboard. And I know for those who have an e-filing account, this is what you would have as your dashboard. You will, when you look at that dashboard, you will see that now we have a button specifically for election disputes. Before, you would have a button for filing of new cases. These are for the mainstream cases, or another button for filing documents, subsequent documents on an existing case. But on the third button, you will see that now we have an election dispute button. So this is how we have customized now the e-filing platform to activate the election petitions. So this you will see, and you will appreciate this more when we do the demo, and Neville will be taking us through the demo. The e-filing system login page, let me be very fast because this can only be appreciated through the demo. I'm just showing you an overview. What you're seeing on the screen should be an e-filing. Let's get to the e-filing system login page. Maybe this is important for us who have not filed cases in courts within Nairobi region, but this will basically be your login page. And then let's go to the creating of an e-filing account. An e-filing account, you can either create one as a law firm, you can create an account as an organization. We have organizations which file documents directly with us, so they have an e-filing account, or of course, as an individual. As an individual, this is when you are, filing a case as a self-represented litigant. As an individual, then you will not be able to represent any other party. So you will have your law firm registration, the law firm number, email address, and mobile. All these are simplified, and the system will prompt you on how to have and how to create an e-filing account. Let's go to filing an election petition. Please keep this in mind, even as we are doing the demo. When you're doing filing of an election petition, I told you there are 3 buttons. The first one is file new case. Please, if you're filing an election petition, don't go to file new case, even though it is a new case. That is for the mainstream cases other than EDR matters. When you're filing an election petition, go directly to the 3rd button where you have to then file. And remember what I told you, that there are 3 categories. You can either be filing a petition, an appeal, a party list, or a miscellaneous application. This you will appreciate more when we come to the demo itself. And then once the step 3 will be select elective position. Now, if you have filed a case before in an e-filing platform, you will realize that the system has changed when you're dealing with EDR matters. In the mainstream cases, you choose for yourself where you want to file your case. But for EDR matters, it is the system which will lead you to where you are going to file your election petition or an appeal. So these steps have been configured in such a way that you will be led to the right court. And this, we have done this so that people do not file cases in the wrong courts or even in the wrong counties. So once you have elected the position, when you go to the next one, you select the electoral area in terms of in which county was your petition held. For instance, in the next slide, you will see if you choose Mombasa, and you will see this in the demo, then it will automatically lead you to filing of that particular election petition in the High Court in Mombasa, and not Nakuru, and not in Nairobi. So the system has been configured in such a way that you will be assisted to file your petition in the right court. And then, of course, you add case parties. And as I said, this we will appreciate more. And I want to go through this very fast so that we can see it in the demo. And then you enter additional election dispute details. We want to you to fill in for us when is the date of declaration of results, because we know that the results were declared on different dates, and we don't have to depend on the Gazette notice. And then you are given up, that's step 7. You are given an opportunity to confirm and submit. And then, as I said, also the court fees will be generated for you. You will see the amount, the invoice that has been generated. And then once you make the payments, you will see them from that particular menu there. So the invoice will come in 2. 1, you will be given an invoice for purposes of paying the court fees. You will be given an invoice for purposes of payment for security of costs. Now you'll get a number only after you have paid the court fees, but you will not be denied to file that petition because you have not paid in respect to the security of cost, because we know that you have 10 days within which to make that payment. So the invoice will be there just awaiting when you will make that payment, but you will still get a case number if you don't pay it on the first day, so long as you have paid the court fees, because that is when the case has been filed. So allow me to jump through this and go directly to, this is now the life cycle of a case in terms of the registry activities. And as I said, this you will see in the demo that will shortly run. Now, once you have filed this petition and we are now ready to have it heard in court, we are saying we have not only automated the registry activities, we are also automating the court activities. The court recording and transcription system will be activated for all the election petitions across the court stations, not only in the Supreme Court, but we'll also have recordings done for the magistracy and then even in the High Court. So election petition cases shall adopt a hybrid system that will involve both physical court sessions and virtual sessions for parties that will not be able to attend the physical sessions. So there will be a link that will be sent for parties who will not be able to attend. And these links will be particular and permanent for every election petition, so that you are not sharing this link with other mainstream cases or other election petitions. So once an election petition is ready to be heard, that particular one link will run through the life cycle of that petition and will be unique to that particular election petition. And we will see why that is why that is important. So election petition court sessions shall be recorded and transcribed. The typed proceedings shall be availed within 3 days after the court rises. So we will have a partnership currently with the Ministry of ICT through the AJIRA program. So we will have the youth who have been deployed through the AJIRA program assist us in terms of typing of these proceedings. That is why we want to have a link which is unique to a particular election petition, so that these proceedings will be continuously typed and shall be of course certified with the assistance of the deputy registrars and the judicial officers in respect to the magistracy courts. And we are saying that within 3 days you will have typed proceedings, and you will access these typed proceedings not through writing a letter to me, to the deputy registrars, but through the e-filing platform. So that when you log into the e-filing platform, you are not only seeing the pleadings that you have filed, you will also be seeing the proceedings as they come in, as they are uploaded on the e-filing platform, so that you will now have a complete file. You will have a complete file, pleadings and the proceedings as they come in day to day. Advocates and parties are required to adhere to the standard operating procedures for court recordings. Speaking through the mics, you've seen the problem that we've had even as we did this, but in court, we will want you to speak through the mic so that we will capture what you're saying, and it will then facilitate the transcription of those particular sessions, so that you have a transcript which is a true reflection of what happened in court. So with that, members, allow me to now invite Neville. Neville will do a demo of what I have talked about. And then thereafter, we will have Yvonne take us through the frequently asked questions, and then we will now have a conversation and engage with the system. Thank you. Neville.
Thank you, Honorable Tanui. The President, Court of Appeal, President LSK, Vice President, LSK, Deputy Registrars present, staff of the ICJ and members of the JCE present. Good afternoon. As indicated by Honorable Tanui, I'll be taking you through a quick demo of the e-filing system and just highlighting some of the aspects that are critical and that we should not do as we are trying to file, as we are filing cases through the e-filing platform. So I'll start straight away by sharing my screen. Okay, I believe you can now be able to see my screen. Okay, fine. So this is the moment you have logged into the e-filing platform. I've now logged in already. But before you log in, as Honorable Tanu indicated in the slides, you'll have access to this login page where you can now create an account or be able to log in if you already have an account. So that being a straightforward process, I'll just go direct to the actually the core thing, which is now filing an election dispute. So just even a refresher from what Honorable Tanui told us, for the normal mainstream cases, this is the file new case button that has been there before. But now with the special interest for election disputes, we have this button specifically for filing election disputes so that it is more specific and relevant. And this is the listing of all the cases that you have. So like you can see Garissa, we have like 2 cases. And I'll use that as an example so that after we have filed, we see that we have more cases in that High Court. So if we start with the election dispute, the first thing is to select the nature of the case, as even indicated in the slides by Honorable Tanui. So we can go with the example of an election petition. And then you pick the position involved, let's say it's governor. And also these positions will render different interfaces depending on the position, we are going to see different interfaces so that you are guided in the right court. So if you go for governor and proceed, the first thing you have to know is in which county was this election held. So I can go with Garissa. Then I pick the filing bundle, which I'm filing. If it is human rights, Constitution and Human Rights election petition, which is now in the High Court, and it's because we selected governor. Governor, we have to go in the High Court. Then in this, the second aspect is to specify which documents you want to file. And the mandatory documents are already pre-filled for you, which is the petition and affidavits. These ones, they are mandatory for you to file them. The rest are optional, but you can also indicate the ones that you have. If you don't, you just leave them like that. Then you specify if you have any other application. This can be an application under certificate of urgency or any other that is relevant to the case type. But if it is none, just pick none. And the system will indicate to you where your case will be filed and the expected court fees. So since we picked a gubernatorial election in Garissa, our case will be filed in Garissa High Court. So if you're okay with that, and we also shown where Garissa is located. So you can have a court name like Milimani, but in the case is located in Nairobi. So if you're okay with that, now you can now proceed. So to proceed, you go to the next step. So this step is to add the case parties. And on the case parties, something very of interest to note here, the case parties, you have to be keen on the categorization. You can add an individual, or you can add a non-governmental organization. This is a private organization, or you can add a state organization. The relevant one in this case will be IEBC, or you can add a political party. So for political party and state organization, you're going to pick them from an existing list so that we have a uniform account for this state organization. You don't have so many fake accounts for this. For an individual, you just enter the details. So let's say it's the first petitioner. Then we add the ID number. And also one thing you'll note that some of these details are only mandatory for case parties that are initiating the case. So somebody like a petitioner is the person initiating the case, so it is mandatory you have all these details. But for a responding case party, is not mandatory you have these extra details, since you may not be able to have access to all of them. So let's say we add a name here of the petitioner. Let's say Onyango Njuguna. Onyango Njuguna Korir. Then the gender, you specify if it's a PWD, persons with living with disabilities. This is critical for statistics for JCE to know that out of the election petitions filed, how they were distributed across different demographics. Then the year of birth also to determine if they are youth filing cases, just for statistics, the nationality, telephone number. And then the email address, let's say like this, kamau@org, and that one. Then we save the case party. So we now have the first petitioner. The second petitioner, we can, if it is a state organization, you have to specify which state organization. If it is, you have to specify from the categorization. So you have a categorization here. We have commissions and independent offices. This way you're going to find IBC. We have also a organization like institutions, like KRA. You'll find them under institution, agencies, and authorities. Ministries are under this one. So for EDR matters, the relevant one will be IBC. IBC will be under commissions and independent offices. If it is a political party, you have to pick it from the list here. So let's say if you add a political party as a respondent or as an interested party, so we just pick. So for in our test environment, you only have one configured. Then you add the party. At this point now, you have to upload the documents, and these can only be uploaded for the initiating case party. That is the petitioners only. So you pick from the bundle we specified in step 1. So it was an election petition. Then we have the documents we want to file is a petition. So we name it appropriately. Then we pick from our computer. So it is a petition. Upload. We also upload the second one. The second one still under this. It is an affidavit. We name it appropriately again. Affidavit. Choose the file. Upload this. And also at this point, if you have a document that is exceeding 50 MB, the system will just give you a notification that this document is too large to be accommodated by the system. You just upload the cover page, and the rest, the other soft copy of the document, you present them to the court, to the registry. So if you go now to the next step is to enter any other details that pertain this kind of case. So for this case, we have to specify the date of declaration of the results. As you remember from Honorable Tanui's presentation, these dates vary from election to election, from county to county. So you just pick the relevant date, and the date can never be in future. It has to be behind the current date. Then the case summary, the date file, the system will automatically pick for you. The case summary, then the prayers, and this you can enter as much text as you want. Then you proceed to the next step. The next step is where you see the summary of your case details. And if you're okay with all the details are well captured, you can now confirm and submit. And one thing to note here is the e-assessment of the fees. You can see we have the court fee is 30,100. Then you also have the security, of course, and this one also varies depending on the elective position involved. This automatically assessed by the system and invoiced to you. So the expected fee to be paid is 530,100 shillings. So if everything is okay, you confirm and submit. So our case is successfully filed within a record time of not more than 5 minutes. We have filed an election petition by having everything ready. So you can confirm from under Garissa High Court, we had 2 cases. We now have 3 cases. And this is the latest one, 12 seconds ago, but without a case number. So if you want to now pay for this case, you can have all your case details here. The case parties are indicated. The case activities will be indicated here. If you want to file further documents, maybe when you're filing at the first step, there are documents you forgot to file, you can come and file them here. Even when the respondent will be responding, we'll file documents from here. Documents from the court will be indicated here. Case fees, now this the most interest at this point is now where you want to pay the court fees, and it's billed differently. Deposit, that's the security, of course, and the fees. So if you want to pay, if you just specify pay now, you're given instructions. So you choose the payment option. If it is M-Pesa, you just enter your phone number and you'll get a prompt to enter the PIN and proceed. If it is KCB M-Pesa, there is instruction there. KCB Bank, also instruction. If it is RTGS, now for these huge amounts, also the instructions are there for you to be able to pay. And the case will be always having a tracking number. So upon successful payment is when you get a case number, is when you now get a case number at this point. So I'll quickly highlight what is differing from for other case categories that are EDR related, but I'll not finish all of them since the process is similar for all the case types. So I'll just highlight what is different. So if it is a party list, where we mentioned the likes of the nomination list. So a party list, you can either be dissatisfied with the list of Senate, National Assembly, or the County Assembly. So if you pick County Assembly, you have to specify it is for which county so that you can only file for courts within that county. So if I pick it's for the County Assembly of Mombasa, I'll only be able to file in a court that is within that region. If I say if it is for the Senate, I can file in any high court in the Republic of Kenya, since we only have one Senate. The same for member of county and National Assembly. So if it is for the Senate, let's say I want to file in Mombasa County and proceed, I'll just pick the bundle, still the same as we had in the previous one. If there is no, I specified where my case is and confirm, then I can now proceed to the second step. So the second step, add the case parties. So I'll quickly add this, a case party like a political party. Let me add this as a respondent. So can quickly add this other one. First petition and then the name. So I just want to indicate the step that is different. Date of birth. And email. Okay, you upload the documents. So other one. Okay, so this for this case party type, the only for this case type, the only step that will be different is the third step, where we need to add we need to specify what is relevant to this. So we need to pick the date of Gazette notice when this party list was filed, and also you specify now that it is for which political party. A political party can still be a case party, but also you have to specify this list that I'm contesting. In case it is not, you have not specified that as a case party, you have to specify the political party, then the case summary and prayers. So for this, the last step is still similar to the previous one. So you can now proceed to the rest. So for the other one, which is the election appeal, for the appeal, what is the only thing that is different for this one is you have to specify the court rank of the previous case. So if it was a case in the High Court, you have to specify it was which High Court. If I say it is in Mombasa High Court and the nature of the case is a civil case, then proceed. The system will just indicate to me where my case will be registered. Because it was in Mombasa High Court, it will now go to Mombasa Court of Appeal. And I'll proceed to add the case parties and specify the details of the previous case and be able to proceed. So that is all in terms of the EDR case filing process and what is new. I think that is all done. And I welcome the Q&A session. Back to you, Honorable Tanun. Thank you.
Thank you, Neville. Let's now have FAQ from Yvonne. Thereafter, we will have the question and answer session.
Thank you so much. Frequently asked questions. We're going to tackle them. There are around 10 for now. The first one being, how do I file a petition? The current PDF process is using the e-filing portal, whereby we go in the How will I create the e-filing account? Of course, once you open the e-filing system and sign up, you'll be able to visit that. In the event you're not able to open an account by yourself, you can visit the nearest court station that is within your jurisdiction for you to get assistance on filing of the case. The other question is, how do I really need to bring the physical pleading after filing? Yes, and this can always be done within 12 hours of filing online. How will assessment be done? One is on the documents that you're filing on the e-filing system, you'll be required to pick all the documents that you're filing, and with it has an appended fees, court fees. Like right now for MCAs is 15,100. For the counties, that is gubernatorial, MPs, senators, and women rep is 30,100. And of course, we have the deposits. So all that is predefined in the system, and it is easily captured, and it's just a click away. Can I file even over the weekend or past 5 o'clock? Yes, you can file. The system is open 24 hours. You can always file at whatever time that you will need. How will I know the case has been properly lodged? Once you make payment, you'll get a case number, and that one is an indication that you've already filed your cases. The most critical thing that is important is that as you scan your documents, make sure the scanner has the best precision and resolution for you not to have shadows as you scan your documents. They must be clear. Or if you're making your documents, make sure you save them as PDF documents. Can I know the time documents have been filed? Yes, the documents on the system are time-stamped. So it's easy for you to know at what particular time was the document lodged and who did it and from where. Does IBC pay fees? No, IBC is a state organ enshrined in the Constitution. So for them, they're exempted from paying fees. But all the others will be required to pay fees. How do I get help when filing? We have an online support link that runs from 9 a.m. to 4 p.m. Where ICT officers will be able to help you. But we also advocate if you are near a court station, please visit the court station for you to be able to be assisted. We also have our lines, our open lines, one for the customer care at Milimani. You'll be able to be assisted once you make a call. And also we have an email where you can write an email request for you, and then you can be able to be answered within 10 minutes. ICT support@court.go.ke, that one we can do it. The other question and the last one is, when will the judges and magistrates be gazetted? Of course, the gazettement will be done once we get a full list of all the petitions lodged within the court stations across the country. Thank you.
Thank you very much, Honorable Tanui, Neville, and my partner here, Yvonne. That is a wonderful representation of the new way in which we're going to be doing things. Thank you so much for taking us through the system and how it works. We have been seeing questions coming in on the chat section. So now we're just going to allow our panelists to respond to some of the questions. The first one, and I think this is a very interesting question, is targeted towards probably Yvonne, and I think she might have answered it, is how can you check for the presidential election petition on the e-filing system? I'll give either Honorable Tanui or Yvonne an opportunity to unpack that question. The next question is, how do you file a third-party application for a presidential petition using that system? Yvonne or Honorable Tanui or Neville can answer the question and also demonstrate if possible. The other question that has come up, Unfortunately, we can't see who has written some of the questions, but the question on third-party applications was filed by our colleague in the sector, Madam Christine Konge. Another question that we have seen here is, I have a problem using the system because it hangs on the page showing update details. After I update my details, no change happens. Is there something I'm missing out? It is an anonymous attendee. So I think two things, you can either address the question or rather you can direct him to which court station is nearest to him and he can get more help. So you will decide how to answer the question. There is another question, and I think this is at the heart of all the advocates, is what is the supporting legislation for security of costs, bearing in mind that costs for advocates are currently guided by the ARO, and the security of costs required is therefore not supported by the ARO. I will ask Dudley to address the question on that. And the last question is, in what mode or vehicle does the application for scrutiny get made? So we will take a few of those, and then we can move on to the next question. So we can take that as the first batch, and then we can proceed to the next. So in no clear order, Honorable Tanu, you can lead the path on how to answer the questions.
Okay.
Thank you.
All right. So thank you for the questions. The first one on how can you check for the presidential election petitions filed on the e-filing system? So just the way, files in the registry are for particular parties, you can only get access to this particular presidential petition if you have access to that particular account. So the account can only be visible to us, of course, because we are internal users, but can only be accessed by the parties who have an account with that, with the system. So that is the only way, unless, of course, those parties then decide to share with us. That is how it will become public. But for now, I can only access it myself because I'm an internal user, but it's also accessible to the parties who have an account with the system and are the ones who have filed it. And of course, the respondents who will be given access to file the responses to it. I'll also ask maybe Yvonne to add to that if there's a technical bit to it. On how do you file a third-party application for a presidential petition, I will ask Neville to demonstrate that for us. And then on the update of the details, I will ask Yvonne to please answer that.
Access to presidential election, like any other case, you need to request for mapping. But for this particular case for presidential, we'll only give access to the respondents who will be required to respond to the case. Because even for the major part of the people will be spectators, will be sitting either at the lobby looking at what is going on as the advocates will be working on it. On the issue of update of details, of course, yes, we know there's usually a problem, especially if you've missed out on the alternate phone number. So for this particular person who has requested this, would want him or her to join the support link that is currently ongoing. You can see some people have joined in. I'll share it with you so that you can also share with them, where they can always join in and request for answers and support.
Neville, are you ready to do the demonstration? Or we can
Yes.
take a few questions as you prepare. Okay, then proceed to do the demonstration. Thank you.
Okay. So I respond to the first one. How can I file an application or a response to a case? Number one, as a follow-up answer to the question Honorable Tanui answered, if you are a case party, you have the access to the case, you have just to come to the specific case you want to file something to. Let's say this case we had of Garissa High Court. So I'll go to my cases of Garissa High Court, then come to this case, let's say this one, and I want to file a defense. So under lodging request, this option here, there is an option to file additional documents. This one applies to both the person who filed the case as well as the respondent. So if it was the respondent that wants to file a response, it is this Agano party, then I select, wants to file a fees. So you'll have to specify, am I filing applications, defense responses, or memos? So if I pick this option, I should be able to select the response I want to file, then just pick the document. You now pick the document from your machine. Let's say it is, let me just pick a sample document, proceed. You specify what the document is. Let's say it is the answer to petition. You give it a name. So let me just a name like that. Then you upload. You upload the document. You'll also be redirected to payment to submit the fees and also pay the required court fees. So all the documents will be seen here since you have not paid, and this has been filed by the respondent. I cannot be able to now pay for it, but now the respondent can now be able to pay for the document and also view the respective fee charged. So that is the option, and this option can be used by both the respondent and even the petitioner, even filing further documents. Let me just quickly highlight that because might be, if I as the petitioner, because I selected here as the petitioner, also have the option to file subsequent documents that I forgot to file in the initial filing stage, as well as any other general documents that are zero rated, so that I can also be able to file. So picking on the option, the system will guide you and it will be able to file. Then also another thing that I just want to quickly highlight is if you want to view a case, the details of a case, if you have a case number, there is this public information kiosk here. You can just specify the court you want to view, specify the language, then you can now narrow down to a specific case and the case number, and you can be able to view the brief details of the case. So that is for the general, anyone interested in a case and you want to view all the any details about a case. But now the specific details will only be applicable to the case parties. Yeah. I think that answers the question that was asked.
Neville, while you're still in the platform, maybe you could take the question in respect to how do I know the right court, for instance, in respect of county elections where we have more than one magistrate. So since you're on the platform, so that we don't come back to you, just answer that question.
Yeah.
And just demonstrate.
Okay, fine. Let me go back. Just share my screen again. So when you're filing, the first thing that is done is on the judiciary side, in the internal system, they have to configure every court to a court, every electoral area to a court station. So, and there are scenarios, we can even use scenarios of, you have said member of county assembly. There are scenarios whereby we have, let's say, even 2 high courts in one county. So a common one is Nakuru. Nakuru, we have Nakuru County, and which has Nakuru High Court and Naivasha High Court. So for this, it has already been configured in the system that one of the counties has already been, one of the court stations has already been configured to redirect the matters to. And for the, now when it comes now to the wards, we configure them to the nearby court station. So let me take the example of Mombasa, then I pick Changamwe. So this being a member of a county assembly, I'll have to narrow down up to the county assembly. Let's say it is these portraits. Then election petitions, I specify this, then none. So I'll be shown where my case will be filed to before even I have to proceed. So the first thing you have to confirm at this stage is, are you okay with where your case is going to? So this is the first point to confirm. And these cases, this mapping of court stations has already been done internally in the case tracking system. So for all of them, and wherever there are 2, we have mapped only to 1. Like for Nakuru, we have only mapped to, for gubernatorial and senator, we have only mapped to Nakuru High Court, but not Naivasha. But when it comes now to the member of parliament, for member of parliament of Naivasha constituency, that one is mapped to Naivasha High Court. And for member of parliament of, let's say, Nakuru West, that one is mapped to Nakuru High Court. So when it comes to constituencies, we pick the nearest high court if there are 2 high courts in a county. But now when it comes to county level elections, we pick 1 high court that is mapped to the system. Yeah.
Thank you, Neville. So we have configured this system to make it simple for you. You don't have to struggle with where do I file this case. So long as you know the electoral area in terms of county, constituency, the ward, the system will then lead you to which court are you filing that to. The system will also pick the filing fee for you. It will pick the security of cost for you. So this system has been built with what is already provided for in the rules. You don't have to struggle.
Thank you very much, Honorable Tanui and Neville. And I have seen another question come in. The person has asked to remain anonymous for now. How do you file an amicus brief or friend of the court brief at the presidential petition level? Is it possible to do that demonstration? Thank you.
Neville, as you prepare to also demonstrate that, I think we can give Dudley to answer the issue on security as Neville prepares to demonstrate.
Well, that's a question I join in. They say great minds think alike. I think that person has a mind similar to mine. Security for costs is founded on Section 78 of the Elections Act, and it's the one which also specify what amount of security one should give. So it has a statutory underpinning. It's not in the discretion of the Honorable D.F. Tanui over here. Thank you.
Thank you very much, Dudley. I've seen two more questions come in and I will table them, then the panelists can answer them even as we wait for the live demonstration. Alex Washira asks, how does the judiciary intend to deal with instances in which a singular case number has been assigned to two or more different cases? I think that was touched on by Neville, but can be buttressed by Yvonne. And the next question is from Dan Nyongesa. How do I know the right court, for instance, in respect of county elections? I think we have already discussed how to assign the court, so it's already pre-populated and you will not have a challenge on that. The anonymous attendee asks, for the automatic proceedings, do they come already certified or do we need to apply for certified copies? So I will ask my able panelists, the ladies, to address those two questions.
The certified proceedings, so this is how the certification. I see that every election has a link, and that link will be found. And the proceedings in this section, that particular election petition, will be uploaded as a from
in respect to proceedings, this is how it will work. Every election petition will have a link, and the proceedings in respect to that particular session that has been recorded will be uploaded as they come through from our transcribers. Now, we will only give you access to view once you have made payments for it. And once you have paid, and it is now a general figure of 1,000, whether it is 100 pages or 1,000 pages or 1 page, the figure is 1,000. So once you make that payment, then we will give you the view rights and you can even download, and they will have been certified as at the point of you having made payments. So yes, they will be certified and you will have access to them. Just download a certified copy of it.
Okay, the question on cases sharing a number. Yes, times we have instances where after payment, a case number, for instance, was having number E003, and another one will get an E003, still from the same court stations. Once that happens, the court station registry clerk are supposed to inform us as ICT for us to rectify. Many a times it occurs is that payment is done at the same time, and then the e-payment server picks the same payment reference number and duplicates. So immediately that one is identified, we are notified and we correct that through the requisite payment reference number. Thank you.
Thank you very much. We have a few more questions. We will take 2 more questions. One from Wakabi Madenge. Can the ICT team be able to activate or configure payments in a way one can generate a statement for payments made monthly. Further, have a way to pick out unpaid invoices or ever print out such a statement. It could be a food for thought. Secondly, I see Frank Walukwe saying that Neville hasn't answered the question on third-party applications. They will be addressed in a bit. He's setting up the back-end system, so we are going to address that question. There is another question. There is another question that I think will be posited to Dudley. Since elected members in all other positions other than in the presidential election are sworn in after the election, can one file for an injunction stopping the swearing in of that elected member pending hearing and determination of the petition as an interim application? Because that is a legal strategy issue, I think, Dudley, you can address it.
I think for the president, it's clear that this inauguration is held in abeyance. But assume you challenge the election of all the members of Nairobi County Assembly, and you're entitled to make that application to stop the swearing in. Would it proceed during the 6 months without the assembly fully constituted? That's the question to ask. Why the law maybe does not allow that kind of application.
Okay. All right, everyone can proceed.
Okay, on the issue of payments, if you have an e-filing portal or system or account, once you log in at the face of it on the homepage, under payments, you can easily see how much you've paid, all payments in total, what has been paid and what is pending. At the same point, you can also know how many cases are still active and some are not active, or they are pending payments. So all that is available. Just like what is shared by Neville, you can always see at the right-hand side, like in this account is the balance is, all payments are 4 million and there's a balance and there's an amount that has been paid for. So that one is available on the face of the login page for an advocate or an organization. Over to you, Neville.
Okay. Okay, fine. Just confirming I'm not on mute. So the first question, when it comes to filing as a respondent to a case or a third party, there is a step I think I should also put emphasis on because it's a prerequisite step to do this. The first thing is when a case is being filed, and let's say you are an interested party, you are not part of the case, people listed, the parties listed on that case. The first step will be, first of all, to request mapping to that existing case. And for you to do that, you must be able to, you must know the case number of that case already. Let's say it is a case in the Supreme Court and it's a Supreme Court petition. So if it's just a petition, I just want to quickly show E005 of 2021. So if I proceed, the moment I get all the details of this case, I can now check, am I listed as a case party? Then if I'm not listed, now I'm logged in as a law firm. So if it is a law firm, you have to request for your party whom you represent to be added. So this you request through this option here. Or if you have a party that is already listed, but is not assigned to you as a law firm, the first thing is to request that you represent, your account is attached as the representative of this case party. That's the first thing. So the moment you have this, and of course the court, the registry will have to approve this for you to be successfully linked to this case. The moment you have this approved is when you can now come to a case. Now, let's say I come to this case, the Supreme Court case. I come to, now in the Supreme Court, I come and see the listings of cases I have. If I view the cases here. Now, when I come to a specific case, I'm able to see, you see this option here of filing additional documents. Now, for this option, it will be, the options you have will be differing from the type of case party you are. So if I'm a petitioner, I'll have different options of what I can file, of any other further filings that I can do to this case. So as I indicated earlier, if I'm a petitioner, I can file an application. So that is will be still be applicable to a third party. You can file an application, a response, a defense, or any other general document to this case. So these options you'll have. If I'm a respondent, again, what I'll be able to file, what you have as an application, any form of application you'll have it under this option. Then you'll select the bundle. So if the bundle is application, so depending on for the different case types, depending on what has been configured in the system, you'll be able to find the relevant document that you want to file already pre-configured to that specific case type. So if it is a third-party application, depending on the case type, and this will vary depending on the case types, so there are documents configured for every different case type. So for every case type, you'll find the relevant document. If it is under application, you'll find it still under the application, and you'll still be able to file for that application. So, and this will be still the same, will still apply for filing a response, a defense, or filing or further filing of documents by a petitioner. The same applies, but you have to be first of all linked to this account or to this case and through the e-filing system. Then there's the issue of payments, as in Yvonne highlighted. You can be able to view all the payments that you have from this point here, but we're only giving a summary in terms of the statistics. For now, we are not giving you like a breakdown, like you get a daily breakdown that I was able to pay this and this, this and this. We are only giving you the overall statistics, but you can, in every case, when you go to the receipts section, let me just quickly show you. For every case, there is a receipts section. This section here. This section can show you all your payments for this specific case type, for this specific case under the receipts. So the moment you pay, this one, the moment you pay, all your receipts will be listed here with the transaction number. If it was an M-Pesa payment, you'll be able to see all that through this section, and it is by case. Any other? I believe I've answered the two questions.
And now let me wear my other hat, which is a Supreme Court litigant. Now, the interface you've demonstrated is for the filing of ordinary applications. It doesn't link you to the presidential election petition. I think the president of LSK is still online. Suppose LSK under section 4 wants to join the presidential election petition. How does it do it? The interface you've demonstrated will never lead it there. It will lead it to the ordinary Supreme Court cases, which process you're already familiar with. I think that's the essence of Waluko's question. Which links takes us? Yeah.
Or which link will take me to a presidential petition? So the
yes, to join it as amicus.
Okay, the first thing, that petition. Okay, let me just refresh some things here. Probably we get on the same page, or I better understand the question. So the first thing, when you're filing here a petition and you're specified as the president, the position involved is president, you will go straight away to file a presidential petition. So for you to be able to file any other existing documents for that petition, there must be already an existing presidential petition that you are a case party to. And if you're not a case party to, you have to request that linkage to that specific case that is a presidential petition, so that you can now be able to file further information, any other information relevant for that case. Probably I can invite Dr. Tanui to shed more light on this, especially now from the legal perspective of it.
I think as we prepare for the response of that question, we have also seen a question asking whether some of the matters will be heard both online and physically. I think that has been clarified by Honorable Tanui's presentation. Yes, indeed, you will be able to do some virtual court sessions. So that is not a worry. And they will also be sending a specific link for each virtual court. I caught that from the presentation. So as we also look towards answering that other question, there's Ms. Mutai, you have asked Dudley whether he could repeat his discussion around the security of costs. I think filing fees and matters of money are at the heart of advocates. So they want proper instructions of what to do in regards to costs. And I think after that, we will also just listen to the response on the question of amicus and how to apply for amicus, be it LSK, be it any Kenyan who has a value addition to the presidential petition. How do they go about it? So we will be hearing that from Neville and from Honorable Tanui. But in the meantime, Dudley, just give the response around the issue of costs, and then we will close. I humbly request that we close our question and answer session. We will leave details and support details for the two teams. We can link you up with the Law Society of Kenya, which I'm sure will be taking up interesting litigation as we proceed into the next phase. We will also give details on the ICT team for the judiciary for follow-up questions, particularly those that have challenges with their accounts. So Neville, you can drop in the chat section as well. Your contact, how do people get in touch with you if advocates have challenges across the country? So we will only take those two questions for now. So I'll start with Dudley, the issue of costs.
I'd say that security for costs is underpinned by Section 78 of the Elections Act, and it also specifies what amount you need to pay. There's $1 million for presidential candidates. I'd initially said that I think that this is the reason why we don't see many of them, but apparently it's not being a deterrent this time. There's 500,000 for county and parliamentary elections and 100,000 for member of county assembly elections. So when advocates take instructions, they need to include the deposits, which also cover the security for costs. And if you don't pay security for costs, then the court will not hear your petition and it can be struck out. Then after the end of the petition, the court will release the security for costs after hearing parties again, depending on which direction the case has gone. Thank you so much.
So just a follow-up or an addition to what Neville has told us in terms of amicus. Yes, because we will all know the case number, I think after today, which is pursuant to which the presidential petitions have been filed. So we can use the mainstream platform to file where you are applying to be added as, you know, a party, not as a party, yes, as a party one, and also to represent that particular party. So we will have that dealt with. It seems that there might be a challenge, but it is one of the things that we are picking from this webinar. If there's going to be a challenge, then we are going to ensure that the system is flawless in terms of the amicus query applications. We will look at that immediately after this webinar if there is a challenge. I had sought to just show you how the 4 presidential petitions are sitting. So if I can hand it over to Julie, and then she hands it over to me so that you can see how they are sitting. I'll just give you a preview of how they are looking like from internally, even if I'm not giving you access to them, but you'll just have an opportunity to see how we are viewing them as an institution. Thank you.
All right. Thank you very much, Honorable Tanui. We're looking forward to seeing what is happening in the registry, noting that I think it's 33 minutes to the cutoff time, 33 minutes, and then we will know who has filed a presidential petition. I can tell that all the advocates who are currently in various WhatsApp groups by now have already seen 2 petitions that have been filed. So we will be seeing if there are many others that are coming up. Another question that Frank Walukwe had asked, given that it is conceivable that most petitions will be filed towards or on the last day, thereby overcrowding the system, are there any safeguards for litigants who experience a technical hitch, especially on the last day of jurisdiction? I think this has happened quite a lot, even as we were doing the manual system. So I'll invite Yvonne to just give a quick summary of what to do in the event there are technical hitches on that last day.
Thank you, Julie. We advise that on that last day, in as much as you'll be filing online, it's important also to make sure your documents are already scanned in PDF format, such that when you'll be uploading, the upload will be faster. That is one way. The other thing is we'll also advise the litigants and advocates to also run to the nearest court where they'll find the customer executive officers and ICT officers who have been trained to assist them in uploading and also signing up for that account. So that should be done that is between the working hours 9 to 4, just to avoid the other issues. However, the last day, that is, for example, like today, we have the online link that we might extend to around 5. And for the other petitions that will be coming in after 28 days, we'll also be extending the online link for us to be able to assist all people who will be filing. Thank you.
Okay. Thank you very much, Yvonne, and thank you very much, Neville, and the team for ensuring that everyone can get access to support in the event there are technical challenges on D-Day. I think maybe a rule of thumb is just ensure that you try file the day before so that the following day you can run to the court station in the event there are challenges. So I'll invite Madam Vice President to maybe give a few comments on what has been transpiring, the thoughts from the Law Society of Kenya as we do a closeout of the session.
So thanks, Julie, and I thank the members who have been interacting, and I've seen various of the various comments that have been raised. Frank, you've also raised on the challenge of filing at the last day. I think Honorable Tanui had promised the Law Society that they would have at the registry persons who can assist people in filing their documents, and also to say you're still expected to file the physical documents apart from the online documentation that you shall have. And something that I'm encouraging for us to do, because I know even at the launch, we had a bit of challenges that were raised by some of the advocates who attended, is that can you please interact with the system, try and file, try and put in the nitty-gritty details where you can't get assistance, so that we can raise all these challenges before a majority of the petitions that have to be filed. Now, remember, as much as the presidential petition had a 7-day deadline, so -7 from the 28 days. So time is counting, and I know, or hopefully for the lawyers, there'll be quite a number of petitions that are filed. So with that regard, I think it's time that we interact within this week. We're going to have another physical session at Panari on Friday, and we have invited the JSC, and they will send us a representative. I've spoken to Honorable Tanui, she's here. So we will at least have one member, and the vice chair of the JSC is in session. He's part of the panelists. So in any event, we will have one member attending that day. So please interact with the system, and some of the questions that have not been responded to, I think we can raise them there. And apart from that, the Law Society will strive to have other sessions, other webinars with Honorable Tanui, so that we can ensure that by the time most of us are filing petitions, that we understand and there's a support team. And as the Law Society, we will continue and endeavor to ensure that you get all the relevant assistance to ensure that all our members are well served. Thank you.
Thank you very much to Madam Vice President for giving us a wonderful closeout. I want to just allow the panelists to say one thing as we wind down the session. We will now come to the close. I think we've had a wonderful discussion. I think everyone has gotten some tips and tricks. I think the biggest one is try the system before, not on the day of filing. That's a brilliant one. I'll use that. So let's endeavor to use the system, interact with it, see your court administrators if there are challenges, identify the nearest court station to where you want to file the matter. I think another question, and maybe as we're doing closeout, Madam Honorable Tanu, you can address it, is do you still have to manually serve people even as you file electronically? And do you still have to place the advert in the local dailies on this service? So I will leave those two questions for you as we close out. So I'll start with Yvonne as we move towards Honorable Tanui being the last person to speak on the matter.
Thank you. Mine is to urge everyone to at least file early. And as ICT, we are ready to assist you where possible, both online and on call. Our numbers are also displayed on the e-filing system, where once you can call in any of that number, somebody will be assisting you. That is from 9 to 4. And we can always extend from there. Thank you.
From our Supreme Court litigant, what are your parting shots for this conversation?
I think it's been a great opportunity for me to learn further. And as you say, test the system early so that you don't suffer hitches on the last day. And I look forward to the judiciary giving us that portal for the amicus link. We know that the rule forbids interested parties, but the amicus link, that one we're interested in. I hope it will come up.
Thank you, Dudley. We have seen your interest.
Yes, it shall surely come up. We will ensure that we have that conversation with the developers. Neville is here, Yvonne, and I can see also Mr. Tuya is on call. So we will ensure that by close of business today, we should be having that online. Now, it's been a great opportunity for us to have this conversation. Yes, we are ready to support. There will be a link running every day from 9 to 4. A support link, and we have a duty rota by Yvonne and team. They will be there to assist you. If you have a challenge, either logging in or even filing a document, please ensure that you have that link. There will be people who are going to assist you navigate through the system, and just ensure that any challenge that you have is addressed. We have also have the EDR guideline, which is now on the website. Please download it. It is a simple guideline, just the way Neville did the demonstration is how that guideline has been set up for you. On whether or not you need to serve, yes, please serve. Ensure that you follow the rules as have been set out. Remember, this e-filing online platform mimics what is there in the rules. We are not amending any rules until they are amended. We have not said that they've been amended. If you're required to do direct service, please do. If you're required to either serve through newspaper advertisement, please do it. We are not saying that we have now amended the rules. So ensure that you follow the rules as are. What we have done is just to ensure that you have an efficient filing system and a system which will also enable you to monitor those cases as they proceed online. So for the few minutes that are remaining, I don't know if I can still have an opportunity to just show you how the petitions are sitting currently. So this is one of them. This is one of the petitions. As I said, we have 3 petitions. This is the first one. This is how we see them online. So this, you can see from this that this petition was filed 3 hours, 5 minutes ago. It has been paid. If you want to see the documents, I hope it will open in good time for you to see the documents. We have the security for costs, which is identified, but let me see to the documents itself. This is the petition. Let me open it. I'm now on the live system, so so this petition was filed 3 hours ago. I can scroll it and you can see all the documents that have been filed therein. I'm sure they will be served and we will be seeing this as the day progresses. So this is one of them. There are 4. If I can go to the next. So this petition has the documents as Neville did, affidavit in support. We have address of service. We have annexures, volumes and volume of those annexures. And we are happy that the portal as is able to hold as many annexures as you can. You can see that these are huge volumes of annexures for this particular petition. So that is one of them. There are 3 more, but because of time, allow me to stop at that. And yes, we are ready to support you as you file your petitions. Thank you.
Thank you very much. I think we can give a virtual round of applause for our panelists. For those of you who are still here, you can clap for them because they've really done justice to the conversation. And now I think we are more enlightened on how to do the e-filing process, the various things that are required. And we have also been able to identify a challenge with the system, which is exactly why stakeholder engagement is so critical. So we thank you all for who have raised questions, because with the questions, we've been able to sharpen the system. On behalf of ICJ Kenya, the Judiciary Committee on Elections, and the Law Society of Kenya, of rule of law, democracy, and human rights. We will continue engaging in this discourse. We will continue monitoring the various election petitions that will come up and the various law and the various legal amendments that have to be made in order to ensure that our laws are well versed towards ensuring electoral justice. In this regard, we want to thank you all. Have a blessed afternoon. We are now logging out from ICJ Kenya House. Goodbye.